Mr. Ivy is facing 6 retail fraud cases, and 1 more from district court. The defense is asking the judge for more time to work out a global resolution for all open matters.
Mr. Ivy, state your name for the record, please.
Yes, Ivy. Thank you.
Judge, we're asking for an adjournment in this matter. We're hoping to get a global resolution, and I'd also like to address bond.
But the global resolution includes more than these 6 cases?
Yes, Judge. I do believe there is a district court case as well.
Okay.
8 open cases total right now.
Yeah.
8 open, including these 6?
Yes, Judge.
All right. So how much time would you need to try to get all that worked out?
The judge sets a new date, December 18th, 2025, for the probable cause conference, giving the defense time to combine all the cases into one solution.
I have the 11th or the 18th?
Let's do the 18th.
18th.
Yeah.
Probable cause conference in these cases will be adjourned to December 18th, 2025, 9 a.m. Yes, Esteban.
As to bond, Your Honor, we are asking, I know that we do have low bonds on this case. I think 3 of them, so what?
You want me to let him out on all these retail frauds just in time for the holidays?
Well,
No, go ahead.
Judge,
Go ahead, make your argument.
Yes. Mr. Ivy he was in custody on 3 matters.
The defense explains that Mr. Ivy's family cannot afford the bond. He has 3 children and sole custody of a 5-year-old, now being cared for by his elderly grandmother.
Authorized. So he completed,
Were they retail frauds?
yes, Your Honor.
Okay, all right. So that's 9. Go ahead.
3 more matters here were authorized, so that is why he's back here in Washtenaw. He was given a tether and a cash bond that was posted in Wayne County. And I know that the bond...
His attorney argues that Mr. Ivy was employed before his arrest, and he had been appearing in court regularly until confusion in Wayne County caused his temporary custody.
He reports that he is a father of 3 children. He has sole custody of his 5-year-old, so his elderly grandmother is actually helping him keep his 5-year-old right now while he's in custody. He reports that he is currently employed. He's hopeful that he'll be able to maintain his employment once he is released. He does have a good relationship with them.
He's employed?
Yes, Judge. He was prior to being arrested.
Okay, go ahead.
He was out of custody initially, and he was coming to his court dates, so the court should be able to see that his other hearings he did.
While he was locked up in Wayne County, 3 new retail fraud cases were filed against him, bringing the total to nearly 9 open matters.
To keep up with, and went to the wrong courthouse in Wayne County. Once they realized the issue, they let him go, put him on a tether, but then by then, our new cases were authorized, and that's how he made his way over here.
Oh, are you done? Okay.
Oh, Judge.
Okay. I can't wait for this. Response.
So, Your Honor, in 2021, the defendant was convicted of carrying a concealed weapon and sentenced to 1 to 5 years in the Department of Corrections. I can't tell for sure if he was on parole at the time of these, but it very well may have.
The prosecutor objects, reminding the court that Mr. Ivy has a long criminal history, unarmed robbery, fleeing and eluding, and a concealed weapon conviction.
In 2011, he was convicted of unarmed robbery, and in 2011, he also had another case for unarmed robbery where it looks like he got FIDA along with the 3rd-degree fleeing and eluding, and in 2006, he was, as a juvenile, adjudicated for a felony firearm case related to another robbery. Your Honor, I am asking the court to continue the bond as set, as most of these cases originate from the same location at Macy's, and they're high-degree retail frauds.
Anything else?
And Judge, we appreciate the information about Mr. Ivy's past, but he's been off of parole. I want to say that he's served his time.
Appreciate it.
The prosecutor argues that the new retail fraud cases all come from the same Macy's location, and reducing his bond could lead to more offenses.
So, Judge,
No, but I was listening.
as it pertains to these matters, Your Honor, he was on bond. He was coming to court as required in these cases. And the only reason he's got this new bond is because there were new cases that were authorized after the fact. So he's been compliant with his bond when he was out, but for his mistake in Wayne County, which was quickly resolved, he would have been able to come in and turn himself in and do an out of custody warrant recall on these cases once they were authorized.
The defense responds that Mr. Ivy has been off parole for 2 years, served his time, and has been compliant with his court dates on his previous bonds.
These are nonviolent cases. I don't think that he poses a risk. And yes, it is the holidays, Judge.
So, but he has a violent past and a theft past. And as counsel indicates, he might have been on parole or probation when some of these offenses
No, he
occurred.
reports that he was off, Judge,
Off of.
parole for 2 years prior to these cases.
So, what I'm going to do in this case, though, is that I'm not going to change his bond. I'm going to deny the request for a bond reduction. Let's see if we can get all of these wrapped up or whatever's going to happen.
The judge denies the bond reduction request, citing Mr. Ivy's past record and ongoing cases, saying the bond will remain the same until everything is resolved.
Thank you, Your Honor.